Hi, I'm David Cantor with the Law Offices of David Michael Cantor, and today's topic is going to be indecent exposure. Now, indecent exposure is defined as when a person exposes their genitals, anus, or the female areola of the breast, and there is another person present, and if the defendant is reckless whether the other person would be offended or alarmed as a reasonable person in that situation. What does that mean? Well, you can't walk into a men's locker room and there's a bunch of naked men and say, they're naked, I'm offended, have them all charged, because a reasonable person would expect to see that in a men's locker room. So you have to look at all the categories. The punishment. If the alleged victim, the person who saw it, is over 14 years of age, then it's a Class 1 misdemeanor. That could be anywhere from 0 days in jail up to 6 months in jail. If the alleged victim is under 14, then it's a Class 6 felony. That's, or 14 or younger, excuse me. That could be anywhere from probation with 0 days in jail up to a year in jail, or prison of up to 2 years in prison. That's usually where the guy, you hear stories about somebody who's around the schoolyard exposing themselves to young children. That's where that felony comes into play. Now, the defenses to these charges. One is whether a reasonable person in that situation was not alarmed, such as walking into the men's locker room. We see this a lot in adult bookstore cases. In adult bookstores, they have video booths, and a lot of guys will go there drunk, and guys in college will go there. And in each of these booths, there's a wall that bends around, and there'll be a video, and they'll even have paper towels in there because it's assumed that there's going to be masturbation going on. Well, what will happen is an undercover officer will show up, and they'll go in and purposely walk in and peek around to see if they see anything, and then charge people. And what we've successfully argued is, wait a second, reasonable person would not be offended. You almost expect to see that in an adult bookstore. In regards to entrapment, this is when in a public bathroom at certain parks where there's a lot of homosexual males, and they will seek each other out. The officers know that, and what they will do is go to these particular parks in the bathrooms, and they'll tap their feet under the bathroom stall or next to the guy where they're urinating, and then the guy will turn and face them while he's standing at the urinal, and then they'll arrest him. The last one is what's called a sneak up. That's where boyfriend, girlfriend are at Lover's Lane, and they're parked up on the mountain, and they're getting into it, and the officer sneaks up as quiet as he can be so he can turn on that flashlight and say, surprise. Again, that doesn't sit well with prosecutors, and we're able to attack those charges many times. If you go to our victory section on our website, you'll see that we've had great success in defending these charges. In these defenses also, you'll see that sometimes there's just a mistake of fact. And that occurs when somebody claims, I saw this guy and he was doing something, he must have been masturbating, and they'll say, wait a second, I wasn't at all. I was just adjusting myself, and I was sitting in my car, and you happened to walk by, and nothing was ever visible. So go to our victory section. If you've been charged with this or a friend has been charged, give us a call. Come on in for a free initial consultation, and we'll go over your case with you from top to bottom.